So do we have Gitanjali and Parimal? Mr. Parimal is there.
Check one second. Let me check.
I have joined.
Gitanjali, are you there?
I'm here.
Okay, great. Good
Yes.
morning. Mr. Parimal,
No, I
you
think
have to just increase the light around you, Gitanjali. It's quite dark.
I know. Let me do something about it. It's my on a working day. It's not.
Yeah, this is perfect. It's a spotlight on you now.
Good morning, Jidu.
Good morning. Good morning. Nice to see such a large gathering.
Yes.
Awesome. I
Yes,
applaud each of you.
Good morning, Gitu ji.
Good morning, Neena ji. And,
Good morning, ma'am. Good
yeah,
morning, dear
Good
friend.
morning.
Good morning.
I've
Shilpa,
received
good
a
morning.
message. I've received a message from Miss
Good morning.
Sonal Patil that sir is here with us. So we are ready, and with the permission of Honorable Principal District and Session Judge, may we start with the program, sir?
Yes.
Fine. Sir, Kankan sir, you put it on recording?
Yes.
Yes. With the permission of sir, we'll begin with today's session. And first of all, on behalf of everyone from Team EMW, from IMAS, and from AMP, and from team, I really convey our gratitude and great wishes and thanks to the Honorable Principal District and Session Judge, Mr. Mahendra Kumar Mahajan, who is also the Honorable Chairman of DLSA Pune. It is just, I think, sir, you predicted it so well. You conceptualized this program with the initiative of Ms. Sonal Patil, who's leading this initiative as Secretary DLSA Pune, which has come up rightly and tuned with the press release we are aware of, which is 26th of June, which has come from NALSA and MCPC under the leadership and guidance of Honorable Mr. Justice Surya Kant, who is heading the mediation movement in India. And he started with Mediation for Nation, his very perfect drive, wherein he would want that every court, starting from Taluka to the High Court, they just begin with the drive of referring the most suitable cases, as many as, to the mediators who are working with the districts, with the High Court level. And let us see that how many cases are referred to mediation, and to start from 1st of July till 30th of September, which will be followed by making a data on 6th of October as to how many cases have been referred to mediation and how many of them have been successfully mediated. So this is, I think, the perfect moment for us to celebrate and we be with our Honorable Justice Suryakant in this drive, because he's named it as People's Friendly Dispute Resolution Mechanism in the press release. And taking it further, to begin with, may I please request the moderator from DLSA to first have a brief introduction on behalf of the DLSA Pune. Then we can start with our interaction on this topic, which is lawyers from litigation to mediation and lawyers as architect for the successful dispute resolution mechanism. Ms. Sonal, ma'am, can we have the person take the mic and start with?
Sakshi is here. He will go through the process.
Please. Thank you.
First of all, good morning, everyone. I would like to introduce to Honorable Secretary of District Legal Services Authority, Pune, Srimati Sonal S. Patil, Madam. She is an highly accomplished legal professional with over 15 years of experience. She has served as a judge in various districts across Maharashtra. She also worked as a deputy registrar at the Bombay High Court and has also been assigned to the Supreme Court of India. Currently working as Secretary of District Legal Services Authority, Pune. Ms. Sonal's expertise extend to legal services, human rights, and mediation. She is member of drafting committee of the recent Mediation Act 2023. She is trained mediator from MCPC Supreme Court of India as well as Singapore Mediator Center. Now I request Honorable Sonal Patil ma'am, Secretary of DLSA, to deliver welcome speech. Please, ma'am.
Honorable Principal District and Session Judge Shri Mahendra K. Mahajan sir, respected senior brother and sister mediators, Advocate Pushpa Gupta, Dr. Gitanjali Shetty, Advocate Parimal Shah, Advocate Thangchan VP from Bombay and Supreme Court of India, distinguished brother and sister advocates, esteemed guests and participants. A warm welcome and good morning to all of you. It is both an honor and a privilege to address this esteemed gathering today under the initiative Brainstorming Beyond 40 Hours of Mediation Training, a forum that reflects our shared commitment to nurturing a deeper, more reflective engagement with mediation beyond the foundational training. The theme of today's session, From Litigation to Mediation, Lawyers as Architects of Successful Dispute Resolution, speaks to a crucial and timely evolution in our justice delivery system. It reminds us that lawyers are not merely representatives of legal rights. They are, in the mediation context, enablers of resolution, peace, and constructive dialogue. Advocates are the bridge between conflict and resolution. In the traditional courtroom setting, lawyers are seen as warriors, advancing positions, defending claims, and securing judgments. But in mediation, we are called upon to adopt a different posture, one of collaboration rather than confrontation. An advocate's role in mediation is multidimensional. As an advisor, you help clients understand their legal standing, but also their interests, emotions, and broader goals. As a strategist, you shape negotiation approaches, consider alternatives, and guide clients toward realistic solutions. As an interpreter, you bridge communication gaps, translating legal complexity into simple, meaningful dialogue. And as a problem solver, you work with mediator and the opposing party to find solutions that are practical, lawful, and mutually acceptable. When advocates embrace this role with sincerity, they become architects of enduring outcomes, not just winners of cases. Here, allow me to offer a few practical and field-tested tips that can assist advocates in making the mediation process more effective and rewarding for both their clients and themselves. First, prepare your client, not just the case. Before the mediation begins, take time to brief your client not only about the facts and law, but about the process itself. Help them understand the informal nature of mediation and the need for flexibility and compromise. Second, encourage interest-based negotiation. Go beyond positions and look at underlying interests. Why does your client want a particular outcome? What matters most to them? When interests are identified, creative and lasting solutions become easier to construct, manage emotions, and foster communication. Third, encourage your client to speak respectfully and listen actively. If tensions arise, your calm demeanor can set the tone for de-escalation. Avoid adversarial language, Speak to the person, not just the problem. 4. Think creatively. Don't limit the negotiation to financial terms alone. Explore non-monetary options such as future business arrangements, apologies, or modification in behavior that can add real value to the agreement. And last, be a partner in resolution. View yourself not as someone who wins the mediation, but as someone who enables a mutually beneficial closure to conflict. That shift in mindset is powerful and deeply respected by clients and peers alike. As members of the legal services community, we have a special responsibility to promote mediation not just as an alternative, but as a mainstream method of dispute resolution. At DLSA Pune, we are committed to increasing awareness about mediation among litigants and lawyers, encouraging early stage referrals to mediation, supporting trained mediators and continuous learning platforms like BBFH, and above all, integrating a culture of resolution into our legal ethos. Let us remember that mediation is not about losing or giving up. It's about moving forward, and the advocate has a central role in guiding that journey. By embracing this role thoughtfully, we not only serve our clients better, we also serve the higher ideals of justice, dignity, and peace. I thank each one of you for being part of this initiative. I thank our speakers and mentors who continuously inspire us, and I look forward to meaningful discussions, learnings, and collaborations that will follow today's session. Thank you. Jai Hind.
Thank you, ma'am. Now, I would like to introduce our chief guest of today's program. We are honored to have with us our chief guest of today's program, Honorable Principal, District and Session Judge, and Chairman, District and Legal Services Authority, Pune, Shri Mahendra K. Mahajan, sir, whose visionary leadership has played a pivotal role in the transformation of our legal system. He is a distinguished legal professional with a career spanning over 3 decades. Mahajan sir was appointed as an assistant public prosecutor in 1997 and later became a district judge in 2008. Throughout his career, he has held several key positions, including registrar at the Bombay High Court and Charity Commissioner of Maharashtra. He is a distinguished academic, and his expertise to legal services and administration, and now working as a principal district and session judge, Pune. I request to Honorable PDJ sir to deliver his inaugural address. Please, sir.
Good morning to all of you. Today's program,
Good morning, sir.
From Litigation to Mediation, Lawyers as Architects of Successful Dispute Resolution, held by District Legal Services Authority Pune in association with Team E Mediation Writings, Association of India International Mediation and Arbitration Services, Association of Mediation Practitioner, Training for Excellence in Arbitration and Mediation. All the persons of these organizations, my colleague secretary Srimati Sonal Patil madam, all other esteemed speaker Srimati Pushpa Gupta, Dr. Gitanjali Prabhu Shetty, Parimal Shah, and Thankar Chand VP, and brother and sister advocates. It is the allegation against the judiciary that the litigants are seeking their reliefs or they gets the decision in the third generation. The recent example is in Supreme Court some months back, after 20 the divorce granted by the trial court was set aside by the Supreme Court. 27 years were expended by that couple for getting the divorce. Think about the loss of 27 years of their marital life or their enjoyment of life. Just another couple. After 27 years, if a couple is getting divorced or denied the divorce, what chances are left to them for getting the second marriage or to cohabit with his partner? In partition cases, the grandfather filed the suit and the grandson or granddaughter received the decision. There is no doubt that there are delays in deciding the proceedings, not only civil matters, but in criminal matters also. When Justice P.N. Bhagwati was the Supreme Court judge, the PIL, public interest litigation, and Lok Adalats were started. It was a good example of settlement in Lok Adalats. Earlier, on big scale, Lok Adalats were held and number of cases were disposed of. But that aspect also has some limitation, and therefore now the mediation, a new concept was started. This concept was adopted in foreign countries much prior to the India. It is said that in America, out of 100 disputes, 70 to 80 disputes are resolved through mediation, pre-litigation prior to the filing of the cases. And that is why this concept is adopted as a legal process by Supreme Court of India. Now, NALSA, MALSA, and District Legal Services Authority are doing. It is a compulsion on the each and every judicial officer to send the concept or the intention is that to resolve those matters at initial stage, to avoid more conflict or more relations being spoiled between the parties, or prior to the pre-litigation or earlier stage when the opposite party appears and ready to compromise the matter. It would benefit to both of the parties, and mostly it is benefit to the court. The courts are overburdened. Let me give the example of Pune district. Pune district is having 7,45,000 cases pending in the Pune district. Out of 7,45,000, 5 lakh cases are of criminal nature, and around 3 lakhs cases are of civil nature. Number of under trial prisoners are waiting for their decision since last 8 to 9 years. There are High Court direction, Supreme Court direction, and therefore those matters are being taken preferentially by the judges. And because of that, the civil matters or the small matters, including 138 cases, small offenses like 323, 24, PT cases, money transaction, contract transactions, family disputes are not being taken on priority basis. And therefore, there is a delayed justice. It is the principle that delayed justice is a denied justice. And therefore, mediation is one of the important tools to resolve the matter. It is said that the advocates are the eyes and ears in delivering the justice. Now, the today's program shows that lawyers are the architects of successful dispute resolution. Just like doctor to the patients, the advocates are to the litigants. The patients are having a faith on the doctors. Litigants are having a faith on the advocates and judges. Therefore, the judges and the advocates are being trained by the Honorable Supreme Court and High Court for mediation. 40 hours training was given, number of advocates, number of judges. Today's four speakers are the trained mediators, are specialists in training the mediators how to resolve the mediation successfully. The skills of the mediators, the points to be considered by the mediators at the time of mediation was narrated by my colleague, Srimati Sonal Patil. One thing I want to share with you that some months prior, in the live laws, one advocate gave the remarks of mediator in respect of settlement of marriage. There was a controversy in that regard. Actually, the conversation of the advocate with the litigants or the advocate should not be disclosed by anybody to the media or to the any person on social media, because it is a violation of the rules and regulation. But apart from that aspect, it is our duty, being a mediator, being an advocate or being judges, not to speak personally, which will make the litigants being insulted or feels that they are taunted. The role of trained mediator is to make the parties confident and make them sure that their problem would be listened by the mediator calmly, cautiously, and there would not be any taunt on their acts causing a litigation before the court. Therefore, avoid such thing to advise how they are required to live or required to cohabit or require to behave to the other parties. Our role is only to listen the problems, ask them their proposals, call their proposals, and try to settle on the proposal agreed by both of the parties. It is not our role to advise them how to behave, how to reside, how to live, and how to adopt the principles of religious or social. Therefore, to avoid the conflicts between the mediators, litigants, between mediators and the advocates of the parties, such things are to be required to be shared by me to all of you. I hope that with the enlightening speeches of esteemed speaker, all the participants would get the benefits of knowledge from those persons. They will benefited to develop their skill for mediation and to settle the matters. I am thankful to all the organizations who cooperated District Legal Services Authority and Pune District Court to hold such type of program. I also best wishes to all participants for successful of this program. Thank you. Thank you very much.
Thank you so much, sir. Now I will request to Pushpa Gupta ma'am to take lead for further session.
Thank you. Thank you so much. Thank you so much, our Honorable Chief Guest, sir. Those pearls of wisdom you have instilled in us regarding faith and integrity, which as judges, as lawyers, as mediators, we have to percolate down in the system so that delayed justice is not at all a denied justice in this movement, mediation movement in India, sir. You have actually touched the chord of the problem that yes, it is generations to generations. People are losing faith in the system because there are allegations against the advocates, us also, sir, that we always take every litigation as luxury litigation, a combo package, especially in matrimonial family disputes. People have allegations against advocates that they do not guide us properly and they take, passing on the files to their generation, to their next generation in the office or in the family. So we are in that phase, in that moment where we have to erase these thoughts, erase these beliefs from the system. And your steps, the step of DLSA under your leadership and guidance of Ms. Sonal, also, I think this will be truly covered as a very important milestone in times to come. Such kind of awareness programs, sir, these workshops are basically revisiting the responsibilities which have been put on our shoulder as a citizen, responsible citizen of society. So the points which you have covered and which Madam Sonal Patil, who herself is a very seasoned senior mediator from MCPC, the way she has shared the multi-dimensional role of an advocate in mediation, somebody who is enabler, a bridge, an advisor, a strategist, interpreter, and problem solver. I think she has just given us the complete capsule which is required by the lawyers in mediation. So taking on further from there, sir, I will just share my insights, and then my friends, Dr. Gitanjali, she will be dealing with the pre stage of mediation, the role of advocates in pre-mediation, during mediation, and post, followed by Mr. Parimal's input on the topic. To begin with, Mr. Thankanchan, can I start sharing my PPT?
Yes, you can.
Yeah, thank you. I have to first go back on the previous slide. Let me just see. Is it there, sir?
Yes.
So you can see?
Yes, we can see.
Yes.
Just a moment.
Yes.
Yeah, I'll share. Yes, it's visible now.
Yes.
Yes, from the beginning. So since we are starting with our program under the NALSA and MALSA and DLSA, so let me just take you to the logo of this very august, very important organization, which is National Legal Service Authority, which reminds us that Nyay Sabke Liye, access to justice for all. The foundation, very foundation of this authority is that nobody in our country is left without a justice, and justice which is equal in terms of their status. It no matter from whatever strata of society they are there in the system, they do not feel that they have been left without a judicial remedy and a representation, equal representation in justice delivery system. So this gives us the importance and the responsibility. It comes from the Article 14 of our Constitution, which it's a fundamental right, and it comes as equality before law. We all are aware of this, that equality before law, equal protection to everyone. There is prohibition of discrimination. So the real justice is in terms of equality, in terms of no discrimination on the grounds which are given in Article 14, which is as fundamental due rights available. Then comes the fundamental right is along with the duty which is there in directive state principles, which is Article 39, equal justice and free legal aid. So we all have collected today under this, that we've been working for past 20 years. We are working day in and out, that we are available to provide free legal aid by suitable legislation or schemes or in any other way to ensure that the opportunities for securing justice are not denied to any citizen of this country by reason of any economic or any other disability. So what does this mean? Mediation and justice in legal aid. I'm going to concentrate more specifically on the justice through the legal aid lawyers, and it is relatable to every advocate whosoever participate in mediation. Our first duty starts as an advocate in the justice delivery system. We've all been doing our advocacy in courts, but now there is another advocacy, which is mediation advocacy, which makes us responsible to know that what are our roles in mediation as advocate. And Ms. Sonal Pandit has really reminded us well about how we have to inculcate the respect in our client, that when you are participating in mediation, you have to respect the process, you have to respect the mediator, you have to respect the other side's perspective also, and be flexible when it comes to adopting the process and procedure, and to reach out for a sustainable mutual agreement. So I'll move on. It all starts with you, my dear friends. Before we ask others, see, as advocate, the references of mediation will certainly be exploded, after this press release of yesterday. But every time it starts with us. We have to have an introspection that whether as advocate, I have done my duty or not. Let us not be dependent upon mediator. Let us not be dependent upon the advocate the other side advocate in mediation, or the parties in mediation. First of all, we have to see whether we have done our responsibilities and duty well in advance, before mediation, during mediation, and after mediation. It starts with us. And it is just like daily reflection we have to go through, revisit. Such awareness programs, workshops, training sessions are reminder for us to revisit those chapters which are very important for us to put in practice. Everything has been taught us, but it is for us to revisit. While I was preparing for this session, I happened to go through this training module, which all of you must be holding, which is provided by NALSA for Legal Service Lawyers Part 1. It is, I think, one of the finest draft which has been put in a manual, in a training manual, which I think should be adopted by MCPC also, that how the draftsmen of this manual have put in the basic ethics which is expected by lawyers, not just in from legal services, but advocates, all advocates of the country, their role for mediation, not just in mediation, for mediation movement in country. So we'll revisit those during this slot of mine, and I'll hand over the mic to Dr. Gitanjali. There are certain responsibilities, my dear friends, which are provided in this manual. They speak about the competence. As Sir has also said, that it is about the faith of the parties in the advocate, like doctors. How would you have that faith of parties in you? Only if you are competent in your advice, in your responsibilities, anything which you're guiding. Because Madam Sonal has already said, we are advisor, we are enablers and bridge. We are not going to give them advice as to final outcome which they have to adopt. We have to just allow them to sail through the process in a way wherein they feel that, yes, this is what is in our interest. We've been fighting our battles for rights, but now it's time for us to concentrate on our interest, because if our interests are satisfied, then certainly our rights will be granted to us. So these responsibilities, dear friend, it says to competently perform all tasks entrusted to him, to render all legal services expected of him by the legal service authority. Then the second speaks about quality service expected of a competent lawyer. So what is competence to you? What is quality service? It's not just empanelment with the legal service authority. It is empanelment for quality service. It is empanelment to deliver competent advocacy when you are appearing before courts, or you are appearing before a mediation. So there has to be a competence, diligence, and efficiency and civility which is expected of us. So I'm just taking you back to those training manual pages, which empowers, which reminds us of our responsibilities, which we have to go through, which we have to re-remind ourselves and revisit. It further says to have a relevant knowledge and skills and attributes. When Ma'am Sonal had said that we have to allow parties to identify their interest, to create value by creative thinking in negotiation strategies. My dear friends, just tell me, if you do not have a basic knowledge about the matter in hand, whether it is a family dispute, whether it is a property dispute, whether it is a check dishonor, or any matter which comes, loan recovery, any matter which comes to the mediation center, or maybe the parties come to you for the legal advice, would you be able to guide them as to what is in their best interest? As advocate, we have to form a judgment based on our knowledge related to law, the things which are available in courts, what parties can expect in court, and finally what they can through mediation get. The negotiation and mediation cannot be held by the lawyers who do not know the tenets of that particular law involved. Because how can you enter into negotiation if you do not know that what all a party can propose? These are very important. So if, dear friends, Thankanchan sir, I think somebody is unmuted. If you can help me muting. I think it's Miss Harshada. I muted her. Yes. So the first responsibility with competence comes the knowledge of that particular system, that procedure, that law. If for any reason we do not have the basic knowledge, my dear friend, my request to you all is, please ask the member, the in charge of your mediation center, of your legal service authority, to mark that case to someone else, because this is as good as medical negligence, which a doctor under consumer protection court has been asked to, then there is no amount of money can compensate that negligence. We are not supposed to be negligent in our duties, and we can be negligent if we do not have the basic knowledge of that stream. To undergo continuous training for getting and exchanging appropriate skills. So this step, it's towards that. Today's program is towards a continuous training for us to know as to what are the important things which are necessary for us to apply in mediation also. You see that it casts upon us a duty of legal research, analysis, application of law to the relevant facts, writing and drafting, negotiation, problem solving, which was highlighted by Ms. Sonal Patil also. So would you be able to negotiate or do the problem solving if you do not update yourself with the law, with the judgments, with the legal positions? We will not be able to do that. So how many of us, all of us have been, as mediator from MCPC, this is a training manual which was given to us right in the beginning. And I'm telling you, if I were not a trainer, I think I would not have opened the pages of this manual quite often in my delivery as a service as a mediator. But training, being a mediation trainer, allows us to revisit this. This is Bible, Gita, everything which is everyone is reminded of to go through this. Similarly, for you, the training manual, it really like a constitution of mediation. It has clearly specified the role, the responsibilities of the advocates in legal service authority. Then the communication. It also highlights a communication skill. Ma'am said about language and respect, how the parties have to communicate in mediation, how you will communicate with the mediator as a lawyer. Your communication with the mediator and with the lawyer, the other side lawyer or the parties is also very important. When the parties comes to you for a legal advice, your communication to them should be in a way that they have faith in your legal advice. It should be pure, transparent. It should not be based on any economic advantage. It should be purely for the justice, real justice, which is required at that time. So communication also one of the lifeline of any mediation. One can be bridge or a facilitator only when you have those requisite communication skills also. So it is part of your manual. Then it also speaks about strength and weaknesses to inform the litigant about the positive as well as the negative aspects of the case likely to be considered in court of law. And this exercise, my dear friends, when advocates in mediation, you are casted upon a duty even during mediation. There is a stage wherein the mediator takes the parties and the advocates through the reality testing of their expectations, of their offers, which they have mooted or they have generated. Whether that offer is feasible or not, the parties become flexible only when they know the strength of those offers, viabilities, and also about the weaknesses, which is already there. Those Bhatna, Vatna, Malatna, these are those techniques which a mediator would be using to conduct a negotiation process which is mutually beneficial to both the parties. So this duty, as per the training manual, is there on us, that before parties approaches for the mediation, we have to make them comfortable with the realities of their case in hand, which includes strengths and weaknesses. And these strengths and weaknesses travel during the mediation after every session. The advice which you have given them earlier before a mediation session, every mediation session needs a briefing from an advocate a previous day or maybe just a moment before a session, because the advice which you gave them for a particular session may have to be reviewed in the next session, because now you have come to know the strengths and weaknesses of the other side also. Our participation has to be very effective, very open, has to be very alert, because that is how parties change their positions, and they become flexible, and then they move from their past to present to their future. So these exercises, I'm not working just for the litigant strength. I'm working, we as together, we have to work through our competence and knowledge. We have to see that the important task is when parties approaches us for any opinion for mediation, opinion, any legal advice. Just think of a system in India where we have a huge infrastructure, like we have shopping malls. A shopping mall has many brands. If somebody wants a shirt, a people, just for an example, they have shirts from different brands. But then all cannot afford every brand. They look to the quality, they look to the satisfaction, they look to the pocket, their respective pocket, whether it is valued, a proper value or not. Similarly, friends, the time has come. Whenever, let us visualize that in times to come, we'll have buildings wherein we have these brands, different brands. Party wants a resolution of their dispute. So you as a mediator has to tell them which door, which brand they should choose. whether the litigation is an appropriate place for them to go for satisfaction for resolution, or is it through the other ADR mechanisms, which may be mediation, which may be lok adalat, which could be conciliation, even counseling. The arbitration is something which is not much related to NALSA, but these are those infrastructures, those windows which are available within the system. So our duty starts very much from there. If we are able to guide them, as Honorable Mr. Justice Suryakant has started with, even as advocate, we have to ask parties from now onwards till even 30th of September that this is a perfect case to go to the alternate dispute resolution mechanism. And Lok Adalat has already been there. Only word Adalat has been changed to Lok Mediation. Adalat gives you that, that same feeling of court system, judicial system. But now Lok Adalat have been shifted to pre-litigative mediation centers and mediation centers. So that Adalat word is basically diminishing and people are adopting more to mediation. So let me just come to the next, maintaining confidentiality. As has been highlighted by our Honorable Mr. Mahendra Kumar Mahajan sir, also Honorable Principal District in Session, that judge that maintaining confidentiality is one of the very important thing which we as lawyers have to maintain before and after, during the mediation.
Am I audible now? Am I audible? Oh, I think Pushp has lost connection.
Yes,
Yes,
yes.
yes,
You are
yes.
audible.
You are
Yes,
audible,
ma'am.
yes.
Yes. Yes.
Yes.
All right.
I think she has some network issues.
So if you can check with her, otherwise I'll take over.
Okay. 1 second, let me.
Sorry, I lost
Yes.
connection. Am I audible,
Yes.
sir, now?
Yes,
Huh?
you are
There
audible.
was some electricity
Yes,
issue at
ma'am.
my,
Okay.
yeah,
Okay.
so sorry. Let me just start sharing screen again. Now it's visible?
Yes, yes.
Yes. So I will just try to finish as early as possible because my friends are waiting for them to share. So with this responsibility of strength and weaknesses, as I've shared the confidentiality, sir has also highlighted that it is very much important for a lawyer to maintain a confidentiality. Why that confidentiality is important? Because the faith which a party has reposed in the lawyer has to be maintained all through the stages, even after the mediation. So that is very important for us. And during the mediation, it is one of the duty for a mediator to perform. But those duties have been put on our shoulders by NALSA under this training manual. So let's come to the next one. Then information gathering. See, these are all skills and requirements which a mediator is supposed to do while conducting a mediation. But good part is that these all have been highlighted in the training manual for the legal aid service lawyers or even lawyers who are guiding the parties for mediation. That the conduct and actions would have the character of nobility revolving around the object of espousing the cause of general public good. So you have to require to extract information. Until and unless you don't have a complete information, what is the case, why party wants certain thing, it is just their desire or their need. So only once you are able to bifurcate between wants, desire, and needs, you will inform parties about the options which they can possibly generate in the mediation. And this can only be with a bullet headline, that is with your understanding and a knowledge of that particular field. Negotiation without information gathering, without information of that law which is involved, information about the needs of the parties, is absolutely not possible and is unethical on our part. Then see, even this is part of your training manual. This is perfect for a manual on mediation also. It speaks about maintaining integrity, which is expected of a mediator. It speaks about listening skills, compassion, patience, confidentiality, to frame right questions, and an attitude of respect. See, being an advocate, sometimes we feel that, oh, nothing can happen, that arrogance. People feel that ego is there in us the moment we become advocate. No, mediation has brought us to a scale wherein we have to be compassionate to people. We have to have communication, a respectful communication with people, so that they repose their faith in the justice delivery system. Justice delivery system is now traveling to mediation centers. And this is what a justice in mediation, giving them equal opportunity. So this is, I have not taken it from internet. These slides are completely from your training manual. So after this program, friends, please keep that training manual. If you have a booklet, if you have a photocopy, you can download it from the NALSA website. Keep it on your table. Just don't put it in the library or a bookshelf. The moment the day, even if you just read one paper, you will come to know about your duties in mediation, your duties as lawyer for mediation. Then see, there is empathy also, which is there in this manual. Every problem manifesting in its factual ropes has social, familial, and emotional dimensions. In litigation, in adversarial system, emotions have no roles to play. That is what the basic and most important difference between a litigating lawyer and a lawyer in mediation. We are working for emotions of the parties. So emotional dimension can be worked up only when, as advocate, we first empathize. We empathize in a way wherein parties, it says to put himself in the fact situation in which his litigant is placed, stepping into the shoes. All this is required by the mediator as per mediation manual training manual. But look at the beauty that these have been already been put in the training manual for the mediation for the advocates. These skills are definitely will improve our advocacy in courts also, but these are very, very important for the lawyers in mediation. Empathetic listening, communication skills with empathy, listening skills with empathy. Body language, to listen to the litigant carefully, to look for material information that would help establish a case, not to be dismissive in his body language only because it is a poor person sitting in front of him. Even Ms. Sonal Patil has highlighted about the language that is non-verbal language or body language. Emotions, sometimes parties are unable to put them in words. Through body language, you have to read that whether my party is in some discomfort, would want to say something, and this is how you will connect with them. You will allow them that you're understanding their said and unsaid information. And this is like gathering in information. The more information you gather through these, you will be able to be good enabler, a strategist, an advisor, a bridge in the mediation process. How many of us till now have looked for the body language? It speaks about our body language, it speaks about the body language of parties. Before the mediation movement, I don't think so in my career as advocate I have ever thought of giving any importance to reading someone's body language while advising them for the courtrooms. But mediation has brought us to a position wherein they said and unsaid is very important. And it starts with you. How you behave, how you respect with the litigant, with the party, with the people in mediation. Your behavior, your body language will be one of the determinative factor for a successful dispute resolution mechanism through mediation. And this is what our is the topic of the day. So let's not just work on the body language of the parties, but your behavior in mediation will also be very determinative about the success or unsuccessful mediation. Though word successful and unsuccessful we don't use in mediation, it's unsettled or settled, because all mediations are successful. A case which is settled through mediation agreement is not just a successful matter, but the matter which has gone as unsettled has also been successful in making parties concentrate on what exactly they would want now in litigation also. Earlier they were fighting for 100%, but after your this pre-counseling, pre-mediation drive, all the parties become more focused. So it speaks about, your manual says that as advocates, by listening carefully to the parties, we have to inform them about the legal processes, including ADRs to be adopted in given. So this duty again is on us. It is not something new which we are doing today, which we are supposed to do. It is already there. Only thing is that we have to see which of the door in that whole infrastructure is most suitable to release the parties of their stress of the dispute which they have in relationship or in commercial relationship. Every relationship starts from human. So there are two humans which are just fighting. So venting emotions, again, an important part of mediation. A mediator is supposed to allow them vent emotion. But I am speaking as today, I am speaking not as mediator, but as lawyer. Lawyer in a justice delivery system through mediation. So please give a quality time to your parties when they come. They come to your chamber. Please allow them to vent out their emotions. All emotions are not negative. All emotions cannot be set aside. Emotions, once the parties went out their emotions are interest, needs of the parties. Once they release themselves of these emotions, they will be with you to work through the negotiation, to look for solutions which are suitable to them. They can tailor as per their requirement. So this is again with patience. How many of us has that patience? We always say, अच्छा जल्दी करो यार, मेरा एक और मैटर आ रहा है, आपको आपको पड़ी, हमारे पास तो 10 केस मार्क हो गए, मुझे उसका भी देखना है. We are not supposed to say this. We have to be patient in our communication with the parties. If we are patient, we'll have an active listening, empathetic listening. But if we are already we are already with people in so much is already, we are carrying so much of luggage with us also, our own emotional luggage. We have to release ourselves. We have to be present in our moment with the parties to advise them about the process. As Madam has said, what is the process, how it is conducted, the role of a mediator, the role of parties in mediation. You can only do this when you have patience. You have time to sit with parties. Simply that your matter is marked in mediation, चलो आप आ जाना 2 मिनट पहले, वहीं मिलेंगे, वहीं देखते हैं. No, spend quality time in your chamber, on your table with them before you take them through every session. Every session needs a pre-advice, revisiting on the previous session as to what happened last time, how they have to strategize their this session in a way which makes the movement, which makes the progress in mediation. Compassion and tolerance. Building trust takes time. Our Honorable Chief Guest has also reiterated that we have to build trust in parties, that faith, and that faith yeah. So that can only be through patience, compassion, tolerance, understanding. You see that it says that communication brings balming effect. That balm, that just takes care of their stress. See, so much so is said in your manual. Rather, it has given me many inputs to be a good mediator, to be a good lawyer in mediation after reading things. I have not seen this manual earlier. So I'm grateful to the organizers. I'm grateful to our Honorable Chief Guest and Madam Sonal Pandit to allow us to be the resource person on this topic. We have learned through this exercise. We have learned so many things. So asking right questions. You also, this technique is expected from a mediator, but your manual says it is very important for a lawyer to be able to frame right questions. For gathering an information, you can gather information only by effective, right, important questions, and those questions can only be crafted if you have a domain knowledge. We are not saying about expertise. If you do not know about 138 Negotiable Instrument Act, if you do not know about the HMA provisions, if you do not know about maintenance, if you do not know about labor management disputes, would you be able to ask appropriate questions? Would you be able to gather information? Your communication will be absolutely of no use. It just, we don't have to, just take them as jewelry accessories and, but duty is casted upon us. If a matter is marked, if you do not know about that particular law, please either go and sit in library, sit in your studies room and read about the law before you assist or you guide parties. So creative thinking, even Ma'am Sonal has talked about creative thinking. Generating options in mediation. Sometimes those linear thinkings cannot, traditional thinking cannot give parties a solution which is win-win for both. So that creative thinking needs exploring, it says exploring uncharted courses while suggesting legal remedy. So it is already there. Creative thinking again can be through patience, through active listening, through going outside the box. Why expect this from mediator? Is not supposed to do creative thinking. It is parties along with advocates. So your role, it's really different from court, as has been said earlier. We are not here as warriors in this setup where we are fighting against each other. We are collaborators to look for a mutually acceptable agreement. So this is a code of ethics, my friends. This manual is a complete code of ethics which cast upon us the responsibilities, the dispute, the duty, which is based on trust, ethics, and competence. And the competence includes your knowledge, your skills, your experience, your performance, your behavior before and during and after mediation. So let us look within ourselves before we start, just pinpointing on others. Many times it says the matter got unsettled. We say, यार mediator ने काम नहीं किया जैसे करना चाहिए था. But reflect on you. Whether you have participated the way it has been expected from you, whether you were prepared yourself, you prepared the client in a way which made a progress in mediation. So professional competence and due care is what is expected by lawyers in mediation. Quality control, continuous professional development like these awareness programs. I was looking through the chart of the how many literacy and legal awareness program which have been organized by NALSA from April 24 to March 2025. It is running into lakhs and lakhs, 4 lakhs. It is around 37 lakhs. Advocates have participated in 1 year in these awareness programs, continuous professional development program, and the huge participation today is again speaks about the interest. All of you have taken time out in the morning schedule on a working day to be part of this. So litigating advocate, no, we are not litigating advocate here in mediation. Our role is of facilitating as facilitator before mediation, during and after. It's completely different. Please be aware and watchful of your role for mediation. I'm not speaking in mediation, for mediation. So because it's a negotiation process without knowledge, skill, compassionate, empathetic listening, gathering information is not possible. Problem solving or through creative thinking is not possible if you are not having a bare minimal domain knowledge about the mediation process, about the law, not just the law, but about mediation process. If you do not know what is mediation process, what is the role of a mediator, how the sessions are conducting, how would you then advise parties, their role in a specific mediation session? So please be aware of the mediation process, the role of mediators, and then accordingly prime the parties about this. So it is about intelligence quotient and emotional quotient which is required in mediation. With emotional EQ has no role in active litigation, courtroom litigation. So effective negotiation with emotional intelligence outside the room and inside the room is what is expected from us. Participatory monitoring and evaluation. This is what is our role, participatory role. We are not as advocates who are just fighting for the rights. We are advocates who are participating for the interest and needs of the parties, not just our parties, both the parties, to monitor every mediation session, to evaluate the offers, whether they are executable, whether there is no, because see, these are mostly cases which are there in legal aid. Many a time there is an allegation that when a legal aid counsel appears in mediation, there is the quality is compromised. A person from management brings some expensive senior lawyer, and maybe there is a power imbalance. People are not satisfied. They feel that maybe we have not been provided with justice. That mediation and justice speaks about this. We have to give the quality service to the parties in mediation so that there is no, you can see these two pictures, there is no power imbalance and there is an equality before law, equality in mediation. Let all of us maintain integrity, let all of us maintain competence, let all of us embrace knowledge about mediation, the power of mediation, the process of mediation, and the role of advocates in the third party assisted negotiation process. So not just equality, but you have to work through equity also. This picture speaks about equality with equity. This is what is our role, dear friends. And as Justice S.P. Barocha, he in his writing in Nyaya, he also highlighted about the importance of his lordship observed that teeming millions of this country who live below poverty line in tribal, backward and far-flung areas look to see legal service authorities for help and support in resolving their legal problems. When involved in litigation, they very often feel that they are fighting an unequal battle in which the party that has better financial resource can secure more able legalists. My dear friends, we have to take care of this imbalance in mediation. Please let us take a firm affirmation from now onwards that our approach in mediation, let it be completely different from what you have been doing previously. Even the NALSA, the establishment, the constitution of central authority after the constitution and establishment of NALSA, one of the scheme and measure that had been envisaged and implemented is emphasis on competent and quality legal service to aided person. So this competent quality legal service includes our quality and competence for mediation, pre-mediation, during mediation. So legal aid in mediation, the full form of aid we can say is assist, intervene, and develop. Assist the parties, intervene constructively, develop sustainable settlement agreements with via mediation. This is what the full form of aid in mediation. This is how I have perceived. So for pre-mediation, building a solid foundation during mediation and post-mediation, over to you, my colleague, my friend, Dr. Gitanjali. Thank you so much. Thank you.
Thank you so much, Pushp. So I take the baton forward. From litigation to mediation, lawyers as architects of successful dispute resolution. We could not have thought of a better topic, and my complete applause to District Legal Services Authority, Pune, Maharashtra, Team E-Mediations Writing, Association of India International Mediation Arbitration Services, Association of Mediation Practitioners, Training for Excellence in Arbitration and Mediation. I owe this gratitude to all of you. In particular, I shall also applaud His Lordship, Honorable Principal District and Session Judge, and the Chairman, District Legal Services Authority, Pune, Madam Sonal Patil, Secretary, District Legal Services Authority, Pune, my dear friend Pushp Gupt, for having me deliver these few words to all of you. Like Pushp, I would also join her in thanking you all on a Friday morning to spare this precious morning to inculcate some of the nuances and wisdom of our role in mediation. We all agree that there was a time when we were all running helter-skelter to learn about mediation because we knew somewhere deep down that mediation was here to stay. And the more we learn about it, we realize that we have to unlearn more to capacitate ourselves to become better mediators. Soon and very soon we realized that this can't be a lone journey unless and until we have the complete cooperation of the parties and our learned friends, the advocates, without whom the vehicle of mediation will not even complete the process of mediation satisfactorily, let alone success or talking about settlement mediation agreements. As we all know, the magic of mediation works, but it works when we all cooperate in the role that is being granted to us. And hence, the applause for this topic. Without much ado, and thanking all of you for the wonderful morning session, which was kickstarted by Sonal ma'am, by Honorable District Judge and Chairman of District Legal Services, Pune, and Pushp Gupt, who could not have more than better emphasized on the role of advocates as imprinted and recorded by Nalsa. And we have to keep this book next to us, as she said. Taking a cue from that, I shall now proceed to tell you about the MCPC booklet by the MCPC Supreme Court of India. And in that, there is a wonderful chapter on role of advocates. Now, if we all see what is the role of advocates, we will realize that there is a role much before mediation, there is a role during mediation, and there is a role after mediation. I have prepared a small PPT. One second. Sankachan sir, if you can help me to share this.
Yes.
Is it visible? Yeah.
Yes.
Thank you so much. Okay, so our topic for today, what is the introduction to our topic? As we all know, as students of mediation, we realize that yes, it is a conflict resolution process where a neutral facilitates parties to reach a mutually acceptable settlement. But as I said, the magic of mediation will only work if there is a collaborative effort by people in the room, the parties, their advocates, all working in the same direction. And the most important thing we realize is for us advocates. So even I act as a mediator, but I also act as an advocate for my party before a mediator. For me to change my mindset, I have to move from an adversarial mindset to a mindset of collaboration. How that role can be brought about, how we have to unlearn the things of adversarial practice from going, as we said, to checking out as to how to defeat our opponents to a win-win situation is a journey which we all will have to undertake. Apart from that, as media advocation, I would like to call us as mediation advocates, we have to learn the process of mediation without knowing the concept, without being aware of the process of mediation, without experiencing mediation firsthand. It is impossible to understand its significance and assist in mediation in the right sense. So, advocates have a crucial role in mediation as legal advisors who provide direction to their clients and ensure that the mediation process runs in accordance with ethical principles. What are they? We'll see in a bit. Advocates also function to maintain integrity, confidentiality of information obtained during mediation, as well as ensuring that clients are not pressured into accepting detrimental agreements, agreements which are not going to work for them in the long run. So today we delve into the vital role of advocates in ensuring fair and effective dispute resolution. Most importantly, since the mediation of advocate is very significant, what are the things that we will have to prep ourselves with? First and foremost, we have to be willing to change our approach from adversarial to win-win. We have to be well versed with the concept and process. We have to understand the positive role to be played to assist parties in mediation, have a collaborative mindset, and we have to be aware of our role before, during, and after mediation. Now, this slide just speaks of what I have been repeating continuously. So let us see what happens during pre-mediation. Pre-mediation is before you enter the mediation room. What is it that as a lawyer that you need to be equipped with? Pre-mediation helps you to have a strong foundation. So just imagine a party is faced with a legal dispute. The party needs to appear in court. Which court to appear, where his conflict is going to be met with redressal is something which he will have to first reach out to court. It is equivalent to a comparison which our chairman of District Legal Services Pune made a very good comparison between doctors. The moment we are unwell, we reach out to a doctor. We reach out to the doctor who allows us to go through different tests, who prescribes medicines, who makes us feel better. Similarly, whenever we think about a court of law for redressal of conflict, we think about a lawyer. We are not much aware, parties are never aware of which lawyer dwells into which, and ultimately reaching a good lawyer is something which he works on. Once he reaches out to a lawyer, it is for the lawyer to understand and explain to the parties the different ADR mechanism. Once he has, if there is an arbitration agreement in his dispute, he has to refer the parties to a arbitration. If he sees that there is a plaint to be filed, he has to refer the matter to a suit court. Similarly, if he finds that the matter is good for mediation, there are more feelings involved, that the redressal is based on more of egos and more of clashes of family oriented, much more than legal aspects of the matter, then he may recommend parties to mediation. And if mediation is considered as an appropriate mode of ADR, the lawyer is bound to explain to the party the concept, the process, the advantages of mediation. So that is how he builds a strong foundation. Now, where it is required, let us tick mark what all an advocate mediator will have to explain. First, he needs to explain to parties. The parties are very curious. What am I going to face? What are we going to face once we enter the mediation room? It is the first job of the advocate to explain the role of the mediator so that the party is not met with surprise. The party is equipped with the knowledge that the mediator will never be your advisor. The mediator is only the controller of the process. So he will explain to him what is the meaning of being a facilitator and not an advisor. Parties will then prepare themselves not to seek any advice from the mediator, but to help them act as a facilitator. When parties learn from the mediator about opening statements, they aren't very sure as to how to go about what is to be said, what is not to be said, how we need to vent, what requires to be vented, what requires to be said. This is something the advocate can help them to understand, that you should include whatever you feel, but keep yourself within limits, because you will have to gain more in a mediation meeting. Parties can use their advocates as a practice ground to set forth their case before. There are things which the advocate may explain to the parties that, these are some things that you need to negotiate about. Keep the things close to your heart, and you may be able to use it appropriately when you are in a caucus or when you are in a separate session with your mediator. Right now, when you are in a joint session or when you are doing your opening statement, be perfunctory with only the opening part of what you have to set out in front of the other side. So, significance of what is to be said in an opening statement. I miss the significance of the mediator's opening statement. That is again very important. In a mediator's opening statement, if you when the mediator narrates for the first time about neutrality, a party which has not been educated by their lawyer looks askance and is required to wonder what is the meaning of neutrality. Why is the mediator got to be a neutral? It is the advocates who will explain. So can we then safely say the confidence of a lawyer in mediator to the mediator is the confidence of the parties gained by the mediator. So having an advocate confident about you, confident about your skill in the mediation process is half the battle won. So the advocate explains to the parties what is the idea of neutrality, what is the meaning of confidentiality, what is the meaning when the mediator again and again says that you are in a safe environment. You may say whatever you want to say, because nothing of what is stated here will be carried outside this room. Why? Because the parties, the advocates, and the mediators will all maintain confidentiality. Nothing will be carried in future proceedings. Nothing will be spoken of a word to a single outsider. And that is what is called as a safe environment. But mediator mentioning these things in an opening statement to parties, and the same thing being explained by their own advocates, makes a world of difference. But for an advocate to put that confidence into the parties requires that advocate to believe it himself. So therefore, I say that a mediation advocacy is more about unlearning than about learning. You have to unlearn the adversarial practice and you have to relearn collaborative practice. You have to relearn expressing yourself without being judgmental, without being, having this habit of going on speaking, but more of active listening, and listening in a way not to respond, but listening in a way to understand, to go deeper into why the party is saying things the way the party is saying, and thereby finding out the underlying interest of the parties. Now, when parties speak to a lawyer, they always speak, and lawyers always want from the parties factual matrix. Why? Because we need to file pleadings in court. Now we have to unlearn this, because that is something which the parties are saying for the purpose of the court to hear. But it is not something which so we have to peel the layers till we reach inside within the parties to understand what is it that they really want. So if you as a mediation advocate is able to peel the upper surface and reach the underlying interest, you will be able to help the mediator to arrive at a better solution, resolution for your client, and the time, energy that is required can be definitely saved. Forget the satisfaction that you will derive at the end of it. So, neutrality, confidentiality. Most important thing is that you have to also realize that it is the advocate who must know that mediation is not merely to settle a dispute, but it will be the first place where they will be able to meet their enemy, to meet the person with whom they are having a conflict face to face. It is something that they will never get in an arbitration, they will never get in a litigation. They may get to see them, but they may never get to interact with them the way they will be getting in, and they will be required mandatorily to speak to them while doing their opening statement, while responding to their offers, by laying down their offers on the table. At that point of time, the mediation advocate requires to help the parties to understand. Oh, sorry. Advantages. So parties will always enter a room wanting to vent, wanting to take out their frustration, because no party reaches a court unless the conflict has spiraled to a peak when they have no option but to put their hard-earned money, time, etc. into a court proceeding. Only then that the party thinks of coming to court. So the moment they come to court, they come with a full vengeance to have justice, and in the shortest term possible, in the cheapest way possible. It is for the advocate to help them reach a collaborative approach, to explain to them, to help them reach that passage from ignoramus to wisdom. Again, in a dispute which is very ripe for mediation, involving breakdown of relationship, maybe personal, contractual, commercial, it is for the mediation advocate to help the parties to strengthen and restore that relationship. And how? That is something which the mediation advocate will have to spend time with his clients, with the parties. Apart from this, legal position is also to assess strength and weaknesses of his case. Of course, these are the things which an advocate mediator will automatically be able to do, something which he normally does. But what he really needs to do over and above that is that finding out the underlying interest which can be better satisfied with mediation. Now, therefore, can we now really summarize that when a party comes to an advocate, and the first thing what you do is client education and objective setting. So what do? We educate clients about mediation, give them realistic expectation, clearly explain legal rights and option. We assist them to identify their goals and interests, which becomes the cornerstone of ultimate mediation strategy. It is only later parties will realize that their advocates have prepared them for this arduous journey. Second, gathering and analyzing pertinent information. Critical in this phase is the collection of relevant documents, financial records, contracts, etc. This will help the parties to be prepared when the mediator asks pertinent questions. When the negotiations begin, parties are fully prepared with their Batna, Vatna, Malatna. They know what is their alternative. They know what can be the best thing that they will be able to juice out of this mediation. If at all there is a need, mediation advocates will help them to secure expert reports, etc., which will then later help them before the mediator. Strategic negotiation planning, and lastly, and not the least, preparing clients emotionally and psychologically. See, advocates are completely trusted by parties. Parties with eyes closed and heart closed listen to their advocates blindly. And therefore, if the advocates go about doing their duty in a stellar way of explaining to them the importance of mediation, the role of mediator, and how they can manage themselves emotionally and psychologically, I am sure mediation will go a long way. Now, coming to the job, our job as mediation advocate during mediation, the process has started. We have entered the mediation room. Mediator welcomes us all. There is a sitting arrangement, after which the mediator then begins with an opening statement. So, what is it that is required? One, the role of lawyers is very important. It is constructive, cooperative. Attitude and conduct influences the attitude and conduct of the client. Hence, in order to have a meaningful dialogue between the parties and success of mediation, lawyers must themselves have a positive attitude, demonstrate faith in the mediation process. So many times we know that once the opening statement has started, if it is a court annexed mediation, the advocates say, our matter, we are here before your self because there was an order passed by his lordship referring the matter to mediation. Our matter is next kept after 15 days. So in any event, we are going back to the court. So what is it that you require us to do? Now, when that tonality is set by the advocate, the client, parties before the mediator realizes that this is something which is a fleeting exercise which needs to be passed over before we go back to our job of getting our matter heard and decided in the courts of law. Now, take for instance, us mediators, us advocates who have done our mediation course well. We will come before mediation and we will not only help the mediator to identify the parties, we will help the parties be prepared to make their opening statement and what is expected out of this mediation. We will also explain that we have heard and understood from our lawyers about confidentiality so that the mediator is at rest to keep on repeating the 4 pillars of mediation of neutrality, confidentiality, etc., etc. Because you have a mediation advocate with you. The next big job of a mediator, when you start your preliminary meeting, whether it is a court annex matter or whether it is a pre-litigation matter, is that you have the right stakeholder before you. The best way for a mediator, you imagine if the parties before you have no advocates, how would you identify the parties? Firstly. Second, how will you know? Because all explanation in the world, they will say, I have got a board resolution, ma'am, I am suitably authorized by the company, by the firm, by the LLP to be present over here. For the life of you, you can't be able to explain to that party that having a board resolution or an authority letter is way, way different than being here in a position to negotiate. Otherwise, all that you will be doing is playing badminton. You're going to pick up a negotiation from here and you're going to say, ma'am, I will have to go and ask my board of directors whether they are ready with this offer. Only if they are ready with this offer, I can give you my answer next time. Is that mediation? Will the magic of mediation work? If all that you're doing is that you are having offers on the table, which is carried back and forth, and the person who is actually behind the screen is never in front of you, would we call that as mediation? Therefore, having the right persons in front of you is one big task. And who helps you with that? Of course, the advocates. The mediation advocates are all wise to know that who would be the one who can sit there, negotiate, take a call, take the decision, and move forward. So, moving ahead. Once the opening statement of the mediator is finished, the mediator lays the ground rules. If the ground rules are laid and it is noticed that, just give me a moment. Sorry. So ground rules is laid. If there is a mediation advocate present in the room, full respect is given for the ground rules. The mediation advocate respects the ground rules of keeping his mobile off, listening attentively to what is being said, paying attention with eye contact to the other side, being courteous to the other side, explaining quietly to his parties as to what needs to be said and what needs to be done, explaining to the parties anything which there is a confusion about, and taking over the role of controlling the room as far as his client goes. That is the role of a mediation advocate. If there is no mediation advocate in the room, the battle has to be fought single-handedly by the mediator. The mediator will have to enforce the ground rules, enforce the violence in the room, enforce the emotional outbreaks in the room, which you can think that how difficult it could be. It could even derail the whole process. The lawyer must be prepared on facts, law, and the precedents. Needless to say. Next. Therefore, the going again beyond, how do you guide negotiation during the process? Now, the advocate must enable and increase the party to present his case before the mediator. Now, how he will go about presenting his case? From the opening statement, which will make the issues possible, from the issues to deciding which of the issues will be taken up first, from deciding the first issue to what are the offers on the table, how do you prioritize each of the offers, how to give a reality check to the offers, what to do during the brainstorming session. These are some things the advocate will have to do a role play with his client to make them far more equipped in a mediation. Otherwise, the whole session before the mediator will never fructify to the extent that it requires to be done. Considering that the parties may not always be able to give complete and correct facts, it is the advocate who will then supplicate those facts to the mediator in a very gentle and educative way, so that the mediator is fully equipped now with the information to go forth to the other party. Also, as we said, that definitely in negotiation, parties have to understand what is the meaning of BATNA, the best alternative to a negotiated settlement. If they find that there is a best alternative, there is something that they may get better in a mediation than what they would get in a court of law, they need to continue with mediation. If they feel there is an offer, a better offer somewhere other than mediation, then they have to politely inform the mediator that there is something much, much more fruitful, something which, I'm not going to get in this mediation if it is not singularly feelings, ego issues with the other side. So, but now, what now? What is the worst case scenario? What is the most likely scenario that the parties may face? And these are the things that they can only discuss openly with the advocates. And only, so we all know that there is something called as a subsession. A subsession, so we have 3 sessions, as we and pardon my repeating it, this is just all of us on one page. So we have something called joint session, where we do the opening statement and we come to affirmations of maximum offers on the table. Second is caucus, where we do things which we do party wise, so that we negotiate with singular parties, we pay attention to the issues which are to each of the parties and carry it forth then in a joint session to meet the consensus of all. And then we also have something called as a subsession. Subsession is when the mediator wants to have a single session with either only one advocate, both advocates, or only one of the parties. What does the mediator do when they have a subsession? Now, when a mediator wants to collaborate, wants to seek the support or the cooperation of any one of the lawyers, or there is a statement made which is harming or what is going to derail the process, the mediator immediately calls for a subsession. She calls for a subsession to get that party to and find out whether it was a nonchalant statement made off the cuff or something very seriously was niggling the parties, and help them to ease the creases to move on with the mediation. So it is at that subsession that the advocates can educate the parties to participate and to make it more fruitful. Next, we all know that once each of the issues that are framed, after the issues are framed, then we pick out each of the issues as the parties require. The mediator then gets offers. There is brainstorming. There is a reality check. And finally, the offer is put forth in a joint session and it is nailed. So a draft is prepared. When a draft is prepared, the lawyer leading the main applicant prepares the draft. So only a lawyer, a mediation advocate, will word the settlement agreement in a very neutral way. So when there is an agreement or when there is a email written by an advocate who is not a mediation advocate, he will word it as, I am appearing for so and so, my party, in a language which is completely adversarial. He will put merits of the case as discussed last time in the mediation meeting. My party has said this and other party said this. So he will narrate the entire merit. Why? Because he doesn't know about confidentiality. That was just a mere word to him, confidentiality. So the mediator will have to work on such a lawyer and explain to him that nothing of what was said and done in the session can be ever put on paper in writing or anywhere outside the 4 corners of that room. Now that is a singular difference between a mediation advocate and an advocate who is not a mediation advocate, who is not familiar with the mediation concept or the process. And therefore, when we go to a settlement agreement, you will notice that the agreement prepared by an adversarial advocate will always be one-sided. Whereas when that same agreement is prepared by a mediation advocate, it will be very subtle. The use of unreasonable words will never be there. It will be a collaborative agreement saying the matter had been referred. Several meetings had been held by the learned mediator. Parties have now reached the settlement, which is underlined below. 1. So and so. Parties have agreed that so and so will pay so much. The other side has agreed to receive so much. Now, if you look at the language, Nobody is being one above the other. They are all on the same page. Whereas a one-sided agreement will say that after a lot of deliberation, after a lot of having even undergone loss, party is compelled to pay so and so amount, party will pay interest, etc., etc. So it is where during mediation, when you reach a settlement with the parties, a definite distinction can be made in the agreement drafted by an advocate mediator and an advocate who is not at all conversant with mediation. So can we then summarize this? During mediation, you have to have effective advocacy and representation, which will ensure the client's interest is articulated, heard, and advocating for them in the right way. Employing advanced negotiation skills, which is required in mediation, so that parties are their best interest, the underlying interest is put forth, and parties' emotional and psychological needs are also met and vented. Providing ongoing legal advice. Continuous legal advice is given by the mediation advocate because he realizes that at any stage there could be an impasse, at any stage it could de-escalate, and therefore to keep up the tempo, a mediation advocate offers complete support to the mediator. Now, what is it that is required of an advocate post mediation? Post mediation, the lawyer also plays a significant role. One, if no settlement has been arrived at, he helps the parties to now understand that the magic of mediation is not in the success of reaching a settlement agreement. It is having gone through that entire process successfully. You have learned the process of mediation. You have instilled in yourself the strength to meet your opponents face to face, to set out your case, to understand your case, to know where the conflict escalated. You have become wiser. So, not to carry any heartburns, but carry wisdom within you. If a settlement is reached between the parties, then of course the lawyers put their head together, the mediation advocates help the parties to put in a settlement agreement which is completely neutral in its language, which does justice to both parties and reflects the win-win situation of what mediation is all about. So we summarize it in these words: drafting and reviewing settlement agreements. If there is a compliance required to be done, that ensuring compliance and management enforcement. And lastly, advise parties on future planning and strategy building. So in conclusion then, can we then say that mediation advocacy is an evolving role? It keeps evolving. It's a practice that requires empathy, creativity, and a willingness to see beyond the immediate legal issues. So we can safely say that not all of us can claim to be a mediation advocate. It requires a lot of empathy, which one can't build overnight. It is something which you need to feel for the parties beyond earning your professional fees. Creativity is something which will require you to spend more time and energy understanding way beyond what is required of a normal advocate, and a willingness to see beyond that immediate legal issues, which is so tempting always. While the skills required are different from those of a litigator, they are equally important and ultimately, but they are very rewarding. Ask any mediation advocate and they will say tell you the same. So thank you very much for this. I'll stop my share. Any question? Okay, I will hand over to Parimal now for the third line of. Parimal, are you there? Yeah, thank you so much.
Am I audible?
Yes, 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 yes.
Yeah. Mahajan sir, Chairman of DLSA Pune, Sonal ma'am, Secretary DLSA Pune, other organizers, and my advocate friends, colleagues, and students, law students. At the outset, I would like to compliment the organizers for selecting this topic and organizing this webinar. I also thank them to give me an opportunity to share my views on the subject. I also thank Pushp ma'am and Gitanjali ma'am to lay down the foundation and cover almost all the distance and making it my job very easy to take it forward in a very brief manner. So basically, Pushp ma'am has already explained that what are the ethical standards, code of conduct that the advocates, panel advocates, or otherwise also any advocates in the mediation should follow. And Gitanjali ma'am has thoroughly explained the process of mediation and the role of advocates in the process of mediation. Now, I will look at the subject beyond that because today's theme or the topic is lawyers as architects of successful dispute resolution. As soon as we think, say the word architects, it strikes our mind that architect is a person who conceives and then creates uh, something, a structure out of nothing. They are the persons who will conceive that on this barren land, which is there, which has nothing around it, a good complex can come up. They conceive that idea. They design it. They design it well for the people to go and live into them or to do business into them. So it is the conception and designing of the idea about the structure. And so advocates are the persons who can do it. They can smell or sense that this is the matter which can get worked out through negotiation. And architects, advocates also, by their profession, they are very good negotiators. They negotiate day in and day out in all the matters. They are either negotiating with the court to get a favorable order for their client, or they are negotiating with other side advocates as to how can they get a good deal for their client out of court. So advocates, by their very profession and also by their training, have become very good negotiators, and they can put their skills to use in a much better way in mediation, because mediation is nothing but professionally assisted negotiation, assisted by an impartial professional who is a trained mediator. And with the assistance of that person, the negotiation takes place in an orderly manner. And so advocates can participate into that process of negotiation and get a good deal for their clients. Now, I would take it even beyond that, that advocates have two roles to play in the process of mediation. They can also act as mediators. So we have to look at the role of advocates into successful mediation process from two point of view, that they can either act as mediators or they can represent the parties in mediation. In either way, their negotiation skills come to their help in a great manner, and they can play a very vital role into that. And also, I will take it beyond that, that advocates are not only architects of the process, they are also the engineers engineers who ensure that the work is done on the ground. So they are architects as well as engineers. Architects only plan the design and thereafter supervise the execution of that work. But engineers actually ensure the execution of the work as per design. And therefore, according to me, the advocates have more very important role as architects as well as engineers. They are the foot soldiers. They ensure that things are done properly on the ground, and therefore their role is very important. They need to ensure that there is a very good design of mediation and motivate parties to participate into mediation, help the mediator or carry out the mediation process as a mediator, and also help parties in taking the right decisions. It is the advocates who have to guide the parties. How will parties take decisions in mediation? Suppose if there is an offer on table in the process of mediation from one side, how will the other side take a decision whether to accept that offer or reject it or to seek modification of that offer? That can be done only in consultation with advocate, with the guidance of advocate. The advocate has to guide that, see, if you go to court, you are likely to get this A, B, C. Now, on the negotiation table, you are getting A, B, and maybe you are not getting C, but then see, you can face uncertainty so far as court decision is concerned. Suppose if ultimately, after a long time, when you get the decision from the court, and also court, if the court also doesn't grant you C, then what happens? So instead of that, today if you are getting A, B also, it should be good enough in my opinion. Ultimately, you can take your decision. So that is how the advocates can help parties. They can help them to balance on the scale as to whether it is that the offer is better to accept or not to accept and go back to court. So that way, advocates play a very important role in identifying the matters suitable for mediation, motivating clients to go for mediation, choosing the right mediator, because the mediator should also be a trained mediator, an appropriate person, preferably having the domain knowledge of the area of dispute, and also a person of integrity and competence. And it is the advocates who generally know all the advocates in the bar, and they know their background. So to say that they know the horoscope of every advocate who acts as a mediator. And they can help the parties in choosing the right mediator also, hand holding them throughout the process of mediation, as explained by Gitanjali madam, and helping them to weigh the options, whether the option of going back to court will be better for the party or whether accepting the offer that is coming through mediation will be better for the parties. And also, accordingly, they help in ensuring that the structure is being built the way it is required. And so I call them foot soldier also. And by doing all these things, they can help the parties and the mediation process to move in the right direction, hopefully, God willing, to end in a successful settlement. But even otherwise, even whether there is a settlement or no settlement, according to me, mediation never fails. So long as both the parties come into communication with each other. If the communication is established between both the sides, then maybe in the first round of mediation, they may not be able to take the right decision and they may not be able to work out a solution for their problem. But moving forward, somewhere down the line, that seed of communication sown within the minds of the parties will work, and the advocates and parties can again carry forward the communication, and maybe they can reach a solution. So this is how I see the advocates are very much important architects and engineers in the process of mediation, and they can contribute a lot. I am very hopeful that this process of mediation will be given due importance and it will help the parties to come to a win-win situation, solutions for their problems, and all advocates also will be playing a very important and vital role into that. I'm thankful for giving me this opportunity to share my thoughts. Thank you very much.
Gitanjali madam,
Yeah.
I think Push madam is not there. Right?
Okay.
I think
Okay. We will. I think so. That's that. Pushp is here. Pushp is here.
yes, yes,
Yeah,
yes, yes.
thank you so much. I think there's a lot of network issues at my place. I'm just missing connection after every few minutes. So with this note, thank you so much, Dr. Gitanjali and Mr. Parimal, for adding value and making us aware as to our role in mediation and also as our role before mediation with that, and hope we have done justice with the topic as what is expected in mediation and justice. So three of us have done justice to the topic, and you are always most welcome to reach out to any one of us through the Legal Service Authority team at Pune. Our friends are there in Maharashtra, Mumbai. You can reach out to Dr. Gitanjali and Mr. Parimal for any further session or any clarification. So do we have somebody from the Legal Service Authority? Madam Sonal is here with us. And somebody please inform.
Yes. I think they are sitting there somewhere.
Also, if there are any questions, Push.
Yes, we would, because time 12:30, we've been asked to restrict to the time schedule. I think we don't have Ma'am Sonal right now. So with the permission of everybody, we can conclude this session. And as Gitanjali Ma'am is saying, if you have any queries, we can take 2-3 minutes of the time and we can then conclude by 12:30. The link of the manual is there in the chat box. Dear friends, please go through this, get a printout and put it on your table, because it has really enlightened us also as to our duty while we are there in mediation, not just as mediator, but as advocates. Gitanjali, any?
So no questions, I think. Oh yeah, Preeti has raised a hand. Go ahead.
Ma'am, can we get that PPT slide for our study material, if possible?
Yes, why not? It's
Thank
been
you so much.
prepared for you only.
Thank you so much, ma'am.
Share it with Sonal ma'am, then she can share it with you all.
Will do, ma'am. Thank you.
Thank you, ma'am.
Attention, sir.
Thank you, everybody. Yes,
Thank you, everyone.
Thank you very much.
yeah, Shilpa, go ahead.
Thank you so much.
Thank you so much.
Shilpa, you can unmute. Shilpa, please unmute your mic.
Much for informative session.
Please unmute your mic.
Yes. Can you hear me?
Yeah.
Yes. So I was saying that you all have very well explained how to advocate should assist the parties in the mediation, during the mediation, before mediation and after mediation, and explained very well this process. But I wanted to guide your guidance regarding the many advocates think that they are not able to, because they are not able to participate in the mediation process because they feel that their fees will get affected and their profession as an advocate, it will get affected if they want to participate in participate in the mediation. So how you will answer this thing? Because I think the more awareness in the advocates is required, as if they assist to resolve the disputes through mediation.
Yes. I think, Pushpa, are you there? Your hello? Okay, so what I feel is, see, we all have to go through this phase, isn't it? We all are lawyers. We all were lawyers. We learned mediation, arbitration. Or the initial picture is that, we are going to lose out. It's only when you go deeper into it and you understand the nuances of mediation, you will only learn that you're here to gain. That is my experience. I have become a wonderful aspirant for mediation, mediation advocacy, because I feel that more people are reaching out since the future is mediation. So that initial thing that you feel about it is like when you swim in a pond. Now, what you have to do is not only learn to swim in a pond, but to learn to swim in running water and look at the ocean, and definitely then you will feel a sense of abundance. That is what I feel would be an answer in brief.
Thank you.
You want to add to that, or Parimal? Yes, please go ahead.
See,
Can I ask one question?
advocate, it is a misconception on the part of advocates that it will bring down their fees. Actually, if you see, clients come to advocates for what? They come looking out for solution to their problems. Just think whether in the present system, with due respect to all the good things about the system, but look at the constraints, and within those constraints, are we able to provide them solution to their problems? How many matters reach the final hearing? How many decrees you people have taken from the court, and how many decrees you could get executed? In fact, in the book of execution, a big commentary, in the preface only the author says that travails of a litigant begin after the decree is obtained. So these technicalities don't help the litigants to find a solution to their problem. Mediation helps them to get a solution to their problem. And once advocates can get their solutions to their problems, more and more people will come to the advocates. A dissatisfied client will tell other 10 people, अहो कोर्टात जायचं काय अर्थ नाही आहे, आमची केस आमचं प्रकरण गेले 10 वर्ष पेंडिंग आहे, काही होत नाही आहे, nothing is happening, our case is pending for last 10 years. But if you can resolve the problem of a litigant through mediation, he will go out and tell 5 other people that you go to this advocate, that advocate got my matter resolved within 3 months or 6 months, and it was very satisfactorily resolved. So just think about it, that whether mediation, if you work out matters in mediation, whether that will increase the legal work that you are getting, or the contest in courts will get you more matters. Just compare it. It is the question of direct balance between the two. Thank you.
Thank you, sir.
Ma'am, one question.
Yeah, please go ahead.
Ma'am, just to very good afternoon. Myself, Advocate Kiran Pardeshi. I have just relocated to Bangalore. So if I want to work out here as a mediator, could you please guide me? Because no blood relation here, nothing of that sort. So
You are a trained mediator, Kiran?
I have worked in human resource for 8 years, and then I was pulled into this profession because of family matters. And since 2018, I have my son, and I'm working as a mediator. I've done 2-3 mutual divorces, the 3-4, and I've got that as fast as possible done. Saving the time, energy, and money of the client. So that way, I have done whatever possible from my end, and whatever comes to me also, I make sure that I mediate that and resolve the matter and lower the burden of the court from whatever little squirrels morsel I can do. In Marathi we say "Harik sa wata."
Oh, but Bangalore is the home of mediation, by the way. There's
wonderful.
BIMAC, yes, there's BIMAC, there's CAMP. There are too many organizations in Bangalore which you just need to reach out. You have just settled in. And believe me,
20 days.
yeah. So you are unnecessarily, stressed. There will be a time when you will have so much on your plate that maybe
Oh,
you will
wonderful.
pass on to us in Mumbai.
Oh, wonderful.
So you are in a wonderful city with lots and lots of mediation. You just have
Okay.
to get to the
So
right.
just if I can get connected with the right person, so I'll get to explore.
Exactly. Google is the right connection. You will get awesome options over there, and then you take it by experience. Move to each one of them and take the good morsels and move ahead.
Okay, done. Thank you, ma'am.
Okay, so I think we have crossed our time limit. Push. What do we do? Should we call it a day?
Yes, Gitanjali. With this note, positive note, we take permission of Thankanchan sir and people at DLSA to switch off our meeting.
Okay, I think it is.
Thank you very
Okay,
much.
dear friends.
Thank you.
Thank you so much for this
Thank you.
mediation for
Thank you so much.
movement. Thank you, Ji.
Thank you.
Thank you, everyone.
Thank you for the wonderful session.